And hello again. This is your attorney, Namrita Nutani from the Law Office of Namrita Nutani, PLLC. And I'm here to talk a little bit more about trust funding. In my last video, we talked about why trust funding is so important and how you don't want to give an empty gift box to your child or to your loved one. Or as one of my friends today gave me a funny analogy that I would share with you. She actually said it's like giving an empty envelope when you are going to give a gift in a wedding. If you're considering a gift card in it or cash, and some people do that as a gift. Imagine if we create an envelope, which is the trust, and you put nothing in it, and the person who opens it, it's like an empty gift box, is basically getting an empty envelope with nothing in it. That's definitely not something that we want to do. But today we are going to talk about funding different assets and which assets you would probably want to be owned by the trust and which assets you want as a trust as a beneficiary. And not only as the beneficiary, but in which assets you may want the trust to be a contingent or successor beneficiary and not the primary beneficiary. Of course, there's a lot of planning that goes into it. And this is not a blanket statement, nor is it a blanket advice, or any advice I give you is really not legal advice at this point. And when I say something to you and you're hearing it, it does not create any kind of an attorney-client privilege or attorney-client relationship between us, unless you actually become my client through signing an engagement letter. But that disclaimer done, let's move ahead and talk a little bit about what you can consider or the things that you might want to think about when you are having the trust be the beneficiary. So, like I mentioned before, the primary residence can definitely be put in a trust. The important thing to note is that the trust will now own the house. And your primary residence is your homestead. You get homestead exemption when it comes to taxes, and you want to make sure that you retain that homestead. So it's really important that the trust that is created has that homestead language in it. There's a particular statute that gets put in it, and a good trust should always have that, because you are in danger of losing your homestead if that is not there. Also, even if you do have that language, the homestead language in that trust, even at that point, you want to make sure to make certain that you do not lose that homestead, that you file another homestead application in the appraisal district of your county, and make sure that the clerk actually records it, and you don't get a shock next year, or that final year, to where they'll basically make your taxes go up, because homestead actually has a cap when it comes to taxes increasing with the appraisal of your house. And also, if you lose homestead, it's not just about taxes, it's about the protection that you get, especially in Texas, because you pretty much have a limitless homestead protection, as in your creditors, there's obviously an exception there, but most of the time with lawsuits and creditors and bankruptcy and all of those, your homestead will protect your house from all of these. So it's important that you don't lose your homestead. And that's why you need to make sure that you file a homestead again after you fund the trust with your primary residence. This is only for your primary residence. That's really important that you know that. Also, while filing that homestead, most of the time, your appraisal district is going to ask for a copy of your driver's license, is going to ask for that homestead application that's filled out with the trust as the owner, the new owner of the house. And they're going to ask for a certification of trust or a certificate of trust, so which is also a part of your trust document, should be there, so that you can give them a copy of that. And you just put everything together and you mail it to the appraisal district, and then it gets, you will not have any issues about homestead. So that being said, let's talk about another very common asset that we all have, and that's our retirement accounts. A lot of us have IRAs and 401ks. And a lot of times when people create trusts, they want to know if the trust should be the beneficiary of these retirement accounts. So most of the time, again, with certain exceptions, your trust should be the successor beneficiary of your IRA and your 401k and your retirement accounts. It should not be the primary residence, the primary beneficiary. Your primary beneficiary should still be your spouse, and this is for tax reasons. I'm not a tax advisor, I'm not a CPA, but that is just something that you should definitely know and consider. And if you want more information on it, talk with the CPA. But that is what is done. So just know that when you are putting beneficiaries in, especially for retirement accounts, you want to have your trust as a contingent beneficiary if you're married. The life insurance, on the other hand, depending on your particular situation of whether you want to give those particular assets to your spouse directly versus you want to have that life insurance going into a trust and then after that going to your beneficiaries, you'll have to think about your own you should discuss it with your attorney and make sure that, based on your situation, you have different conclusions on that, whether you want the trust to be the primary or the secondary beneficiary. So that is all I have for you today regarding trust funding. Actually, I have one more thing that I would like to add here, and that's your business. Do not forget to make sure that your businesses are also assigned to your trust, and there are different ways of doing that based on whether you have an LLC or an S corp or a C corp, and you want to make sure that you are assigning your interest in that, even if it's a partnership, and making sure that it does go into your trust. If you have partnerships and you have multiple partners, please, please, please consider talking to your partners about estate planning together, because a huge part of business planning, business succession, business exit planning has to do with your personal estate planning as well. And when you are assigning these interests to your trust, you want to make sure that your partner is also giving consent for it and perhaps has that in the company agreement where you both, or you three, however many partners you have, are in agreement as to how each of you may exit, or if one of you dies, then how that portion is going to be assigned to the trust or what's going to happen. That's a conversation that needs to happen before, and that's a conversation and an agreement that needs to be put into place before. So please do keep that in mind when you have partnerships, when you have a different kind of investments, say in syndicates or other investments in other businesses where you're not even the owner. You may not understand how to assign those into a trust or how your spouse or your children would inherit those investments. So please do talk to an attorney and make sure you have all of those accounted for and assigned in the right way, because otherwise your family is going to lose out on those investments, because there is no easy way of putting a designated beneficiary on that. Regarding designated beneficiaries, for any of them, if you do not have a will at this point, if you do not have a trust at this point, it is really, really, really important that you go into each and every account, and it's very easy to do that. Just make sure that you go to every account, whether it's a bank savings checkings account, it's your IRA or 401k or any other brokerage account you want, or your life insurance if you have them through your employers. Just make sure that you go through their portal, find the place where there always is a place where you can have beneficiaries assigned. If you're working with a financial advisor, if you're working with an insurance agent, just make sure that there is a beneficiary assigned. There's so many times people forget to put beneficiaries and there are no beneficiaries, period. Not the trust, not the person, nothing. So if you do not have, the one thing that I suggest that you do right away, especially if you do not have any estate planning in place, is please go through your list of accounts. Make sure, I had mentioned that in my very first video, make sure your assets are in one place and they are organized in some digital storage. You have all your logins and passwords. Make sure that your spouse and your children can access that. The next step after you do that, if you do not or have not yet had your estate planning done, is to make sure that every asset of yours has a designated beneficiary if possible. Your house cannot have a designated beneficiary, but you can still do a transfer on death deed. For those kind of situations, of course, you want to talk to an attorney or go to Texas Law Help if you're not able to. TexasLawHelp.org is a great organization. It's a great resource for people in Texas, and you definitely can get a lot of information from there. So just make sure that every asset has a designated beneficiary, because the worst thing in the world is for somebody to die with no designated beneficiary and no estate plan. Because if that happens, then that account, the money in it, is going to be very difficult to access. And you definitely do not want that for your loved ones. All right. If you have any other questions, you can always call me. And I am available through Book a Call, which is on my website. notanilaw.com. You can also just make an appointment with me by calling me at 972-814-8620 or text me. And you can go to my website for any other resources under the resources tab. Again, it's notanilaw.com. And don't forget to like and subscribe to this channel for more information if what I have told you is useful to you and helpful to you. Have a great day.